If the Supreme Court ever weakens or overturns marriage equality, what protects you and your partner today? In this deeply practical, step by step guide, I will walk you through the exact legal documents same sex couples and chosen family should have. I explain what each one does, why it matters to LGBTQ plus folks, common mistakes, and how to talk to your partner and family. I'll also share quick notes on federal recognition, hospital visitation rules, and simple ways to keep documents accessible. This is not legal advice. Laws vary state by state, so bring these notes to an LGBTQ plus savvy attorney in your state to get protected faster. Let me ask you something a little uncomfortable. If marriage equality narrowed or overturned tomorrow, would your partner and you be legally invisible in an emergency? Would the hospital call them not family? Would your home, your pets, or even your final wishes be decided by somebody else? Here's the good news. Paper beats panic. The law runs on documents. Today, I'm going to walk you through the 9 core documents, plus one that is a bonus, that lock in your choices no matter what the headlines say. And along the way, I'll flag the most common pitfalls so you don't get tripped up by missing a signature and a random form that probably only lives in your junk drawer. A little bit of quick context because clarity matters. Back in 2022, the Respect for Marriage Act became law. It requires states and the federal government to recognize same-sex marriages performed where they're legal, even if the future court narrows current precedent. It does not force a state to issue new same-sex marriage license if overfill were to overturn, but it does protect recognition of marriages performed elsewhere. That nuance is why planning on paper still matters. And a second quick baseline, hospitals that take Medicare or Medicaid, that's the vast majority of them, must honor a patient's chosen visitors and may not discriminate based on sexual orientation or gender identity. That rule's been in place since 2011, but it's still smart to carry your own signed authorization so staff are not guessing in a crisis. All right, let's grab a notebook and protect your life together. First, the big catcher's mitt for almost everything is a revocable living trust. Think of the trust as your private rulebook for everything. You write the rules while you're alive and well. Things like who manages things when you get sick, who inherits what when you're gone, how smoothly that your partner can keep the lights on if you're out of the picture for a while. Revocable means you can change it anytime. The superpower here, avoiding probate. That's the court's process that's public, slow, and can invite drama if hostile relatives get a little curious. For unmarried couples and LGBTQ plus families, a funded trust is often a fastest way to keep your partner in control without the courtroom. Funded means you actually retitle assets into the trust, like your house, your non-retirement accounts. A trust that isn't funded is basically a big shopping cart with no groceries inside. Example language you'll hear from an attorney, Sam and Alex, co-trustees during life. If either is incapacitated, the other remains trustee and continues to pay the mortgage and expenses. Common mistake? Setting up the trust but forgetting to move the house into it. If you own a home, ask the lawyer for a deed, transferring it to the trust right away. Next, the last will and testament. Your will is the letter the court listens to after you die. It names who gets what, who's in charge, your personal representative or executor, and if you have kids, who you want as a guardian. If you have a trust, your will actually backs it up. It pours over anything you forgot to retitle into the trust. For queer families, the will is where you can also make crystal clear that your partner is the first in line to handle your estate. Example, I give all of the rest of my estate to trustee of the blank revocable trust to be administered as part of this trust. Pitfall to avoid, relying only on DIY will when your situation is super complex, even a slightly complex. If you own a house, a business, kids, family tensions, this is worth a pro. Your healthcare power of attorney, also called a healthcare proxy, is your voice if you cannot speak. This document usually names the exact person, usually your partner, who can make medical decisions if you're unconscious or unable to decide. It's different from a living will. This one appoints a human to decide in real time. The National Institute on Aging puts it simply: the two main advance directives are the living will and the durable power of attorney for healthcare. You likely want both. Two tips that matter: name one primary agent and at least one backup, or your next best choice. Talk to them about your values, not just the form. If recovery means permanent ventilator and no ability to interact, here's what I want. Write those down and keep them in the document. Your durable power of attorney for finances keeps the bills paid and the wheels turning. This is a financial sibling of the healthcare document. Durable means it still works even if you become incapacitated. You pick someone you trust, normally your partner, usually to pay the rent or mortgage, access accounts, negotiate with insurers, file taxes, and keep life functioning. The Consumer Financial Protection Bureau explains that durable powers are typically used for advanced planning because they continue to be effective even if you are incapacitated. Pro tip: ask your bank what they require. Some want their own form on file. And consider whether you want it effective immediately or if a doctor declares you incapacitated. Your living will, sometimes called advance directive or directive to physicians, states your medical treatment wishes. This is where you want to say if you do or don't want CPR, ventilators, artificial nutrition, especially near end of life. It guides your partner and your doctors so they're not guessing. Again, the National Institute on Aging notes the living will and the durable power of attorney for healthcare are the two most common advance directives. Use both. The living will is your instruction manual. The healthcare power names the person who reads it to the team. Tip: many states have free forms on their health department website. Print, sign, witness, notarize exactly how the form says. Hospital Visitation Authorization. You need two of these. Even though federal rules say that hospitals must honor your chosen visitors in Medicare and Medicaid facilities, having a signed form listing your partner by name shuts down any confusion in the moment. Do one that names your partner and a separate one that names your chosen family, like your best friend, your sibling who has always showed up for you, whoever is actually in your village. The 2011 federal regulations require hospitals to permit patients to designate visitors and prohibit discrimination based on sexual orientation and gender identity. Keep a copy of this in your phone or in your glove box. A mini script that you can go by is: I authorize blank to visit me and to receive updates if I cannot communicate. Hand it to intake without fanfare. Appointment of agent for disposition of remains. Yeah, that's a mouthful, but it matters. This form names the person who controls what happens to your body: funeral, burial, cremation, memorial, disposition of ashes. Without it, many states default to next of kin. And if your family doesn't respect your relationship or your identity, that can go sideways fast. Advocacy orgs track this closely. The authority to name a designated agent for your body disposition is widely recognized in state law, and is the simplest way to be sure your wishes are followed. Ask your attorney for your state's version of this form and keep it with your advance directives. Practical tip: be specific about pronouns, outfit, music, rituals, whatever matters to you. Grief fog is real. Specificity is love. Pet Care Directive, or a pet trust if you want the deluxe version. If you're like me, your dog or cat is not property, they are family. A simple Pet Care Directive tells your executor or your trustee who takes your animals, where the money for their care comes from, your vet, any health quirks that your dog or cat have, like they get nervous during storms and the thunder shirt is in the hall closet. If you want a legally enforceable plan with money set aside, create a pet trust. Every U.S. state and D.C. now has a pet trust law. Minnesota was the last in 2016, so you can put real teeth behind your wishes. Tangible Personal Property Memorandum. This little list prevents big fights. Many states let your will refer to a separate signed list where you write who gets specific personal items like rings, art, guitars, grandma's quilts. It's legally recognized in a bunch of states. The key details, it has to be signed by you. It must describe the item and recipient clearly, and it can't be used for money or real estate. If your state follows a UPC style rules, your attorney will show you how to do it correctly. Why it matters? Personal items are where emotions explode. That list is a peace treaty. Let's pause and connect the dots to our reality as LGBTQ plus people. Discrimination still happens in hospitals, in housings, even at the family table. Surveys continue to show high rates of discrimination that affect access to care and financial stability. Paper gives your people authority when bias tries to creep in. Now, how do you actually get this done without a year of procrastination? Step one, calendar a 60-minute power hour with your partner this week. Make it cozy, like tea, snacks, phones down. The goal isn't perfection, it's decisions. Who's your backup? If you're both in the same car, who's the best money brain for financial power of attorney if your partner hates spreadsheets? Which friend is calm in crisis and should be your healthcare backup? Step two, assign the documents. Maybe you take the healthcare documents, your partner takes the financial document, and just split the rest. Use your state's forms of healthcare power and living will. Many of them are free online. Add your hospital visitation authorizations. For the will, trust, disposition of remains, a pet trust, book a lawyer. If budget is tight, look for LGBTQ plus affirming legal clinics and organizations or local bar association referral programs, and they can point you to the correct resources. Step three, sign correctly. This is the number one failure point. Some forms need two witnesses, some need a notary, some forbid your agent to be serving as a witness. Read the signature block, then read it again. Step four, make the oh crap kit. It could be a slim binder or a digital folder that includes copies of your healthcare power of attorney, living will, hospital visitation forms, agent for disposition of remains, plus the front page of your trust and will. Not the whole thing for privacy. Put your physician and emergency contacts on the first page. Keep one in your home, one in your vehicle, and definitely a PDF folder that both of you can access from your phones. Give your agents a copy of the document that names them as well. Step five, tell your people. A 5-minute conversation now saves hours of conflict later. Try this script. If something happens to me, name partner, is in charge medically and financially. If I die, partner's name and executor's name, handle everything. Please support them. If you anticipate pushback, do it in writing too. Clear is kind. A couple of pro tips to round all of this out. Keep beneficiary designations updated on your life insurance and your retirement accounts so they pass directly to your partner. These sit outside of your will or your trust. Ask your primary care provider to scan your healthcare power and living will into your chart. Consider a wallet card that says, in case of emergency, contact blank, my healthcare agent, with a phone number. If you travel, keep PDFs on your phone and email to yourselves with an easy subject line you can search. Review everything after big life changes like marriage, moves, births, adoptions, major purchases. Let me also circle back to hospital visitation for 1 second because this is where emotions run high. Federal rules already require hospitals to take Medicare and Medicaid to honor your chosen visitors and not discriminate. But staff turnover and chaos can cause hiccups. Having the form with names and numbers plus your healthcare power of attorney ends debates fast. Hand it over with a smile is a lot harder to say no to a piece of paper than to a partner in tears. And about what if the law changes? You do not need to wait for breaking news to be protected. The Respect for Marriage Act provides recognition of valid marriages across state lines, but it does not guarantee a state will issue a new license if a future court rolls back existing precedent. That's exactly why these documents matter for both married and unmarried LGBTQ plus couples. Paper creates authority, authority creates access. Let's make this real with a quick story. A couple I'll call Jay and Miguel had been together for 12 years. They weren't legally married yet and had a house, had a rescue pup, and very blended chosen family. Miguel had a sudden medical emergency. Because they had signed a healthcare power of attorney and a hospital visitation authorization on file, Jay was brought into every conversation, no questions asked. Their mortgage got paid on time because Jay's durable financial power let him move money. And when Miguel later joked, "If I die, bury me in that ridiculous glitter jacket," Jay just smiled and pointed to the Disposition of Remains form that already signed. Was it fun to do the paperwork? No. Did it keep their life steady when things were wobbly? Absolutely. Before we end this, here's your checklist so you can hit print and get moving today. Revocable Living Trust. This avoids probate, it keeps control in your family, funded by retitling key assets. Last Will and Testament. Names who's in charge and who gets what. Nominates guardians if you have kids. Healthcare power of attorney. Names your decision maker for medical choices. Durable financial power of attorney. It keeps bills paid and accounts accessible if you're incapacitated. Living will. It states your treatment wishes, especially end of life. Hospital visitation authorizations. One name in your partner and one name in your chosen family. Carry copies. Appointment of agent for disposition of remains. It puts your person in charge of your funeral, burial, cremation. Pet Care Directive or Pet Trust. Make sure your animals are safe and funded. Tangible Personal Property Memorandum. The signed list for sentimental items. Check your state's statute. Last thing, please don't go at it alone if you don't have to. An LGBTQ plus savvy estate planning attorney can turn this video into a complete state corrected plan if in a couple of meetings. If cost is a barrier, check organizations like Lambda Legal, NCLR, and the National Resource Center for LGBTQ plus aging to referrals and low-cost clinics. You've done harder things than paperwork. This is just love, written down. If this helped, watch the next video on exactly how to talk to your family through your plan without starting a war.